So how much money somebody has, of course, impacts eligibility, but it can differ, especially when you're married, with what types of assets those funds are actually in, and whether it's all on real estate or all on IRAs is going to differ, and whose IRAs they're in makes a huge difference as well. So before I get started, just a couple quick reminders that this is meant to be interactive, so you can absolutely send in questions and I'll see those pop up. Especially with a topic like this, I completely understand if questions come up, because just when we're talking to people in person, this is the one that gets the most questions. But a couple other quick reminders that next week we actually will not be having our weekly webinar, because all of us here in our office, all the attorneys anyway, are going to be at a conference. So we'll have to take next week off while we keep learning new things, as we're supposed to do as attorneys. So, but then the following week, we're actually going to be doing our public seminar, our in-person wills versus trust at the Neville Public Museum up in Green Bay. That'll be May 10th, Wednesday, May 10th. There will be a 2 p.m. and a 6 p.m. session for that. So if you're interested in signing up for that, please do so at estateplanninglive.com. And then actually the following week, we're going to have a little bit of a difference from our normal schedule. The following Wednesday after that, May 10th, so May 17th, we're going to be talking about estate planning considerations for blended families. And we're actually going to be doing that one in the evening, just because with that topic in particular, with family discussions in particular, a lot of people work. So that's maybe easier for people to attend. So that'll actually be at 6 o'clock for that Wednesday webinar on May 17th. And then keep an eye out for an email from us after this is over, so that after this webinar is over, so that you can look at the material we'll be sending out to you. One is just sort of a chart of a home, and it discusses things that, planning options that people either try to do with Medicaid planning, and there's the pitfalls of doing that and what they maybe should do instead. So it's just a helpful little summary, but in the form of a home. And then also keep an eye out for the feedback form, where we'll send it out to you. It'll give you a place to give us feedback, any questions or topics that you might want us to address in the future. And then if you would like to have us reach out to you to set aside time to meet, we do offer 2-hour initial consultations. Those are complimentary. So if you want us to reach out to you to discuss any of this type of planning with you or a loved one, you can fill that out, and that'll give us the permission to reach out to you to set aside time then. Okay, so today we're talking primarily about Medicaid eligibility and how to understand it and what that looks like for everybody. So when we're talking about Medicaid, specifically what we're talking about is Medicaid involving long-term care, assisted living care, not necessarily just low income like Badger Care, or there are a lot of different subsets of Medicaid. So specifically what we're talking about is qualifying for long-term care in relation to, or Medicaid in relation to long-term care specifically. Now, kind of first and foremost, just to go through a couple, myths that people often have talked about, or maybe misconceptions people have about this. Medicare does not cover extended stays at long-term care facilities. They will cover stays for rehabilitative purposes. And even then, they only cover a maximum of 100 days. So although it seems like most people, reasonably believe that, well, Medicare sounds like the program that should cover this, it isn't the program that you would be using long-term. So after those 100 days is over, that's when somebody's paying out of pocket. They're paying privately in order, if they're able to, for their care until they would qualify for Medicaid. So that's just a really common misconception. Another really common myth or question we get is how long that look back period is for Medicaid. And we often have questions about, is that 5-year rule that a lot of people are familiar with, is it becoming a 7-year rule? Is that going to be how long they're going to look back from the date of application to see if we made any gifts, if we transferred things out of our names, in order to make sure that somebody's not doing that right before they go into care? That's what the look back period is. But it is not going up to 7 years. There's no talk of that, at least at this time, no serious talk. It's just a really common question we get. And I think it's because at one point it went up from 3 to 5 years. So just know that it is 5 years for that look back period, not 7. There's no talk of it, at least at this time, going up to 7. I suppose they could change that, but that has not been discussed anytime recently. So in order to qualify for Medicaid, though, when we're talking about qualifying for long-term care Medicaid, there's a couple key factors that you're going to want to look at. Well, first and foremost, you have to actually need long-term care. You have to be medically eligible for it. So, you can't just go into an assisted living facility like I couldn't and suddenly say, hey, I need long-term care covered by Medicaid, even if I'm financially qualified, because that wouldn't be what I actually need. But you also have to have income qualifications too. And once you're in long-term care, that qualification is that your income has to be lower than your cost, lower than the cost of care, excuse me. So you have to have what we would refer to as a shortfall. Meaning that you are making less money than your care is costing you. If you're making more money, if you're bringing in more income than your care costs you, that just means that you can cover out of pocket your care. Now, that's obviously not taking into consideration like living expenses or anything like that, but that's how Medicaid would look at that. So if you are making less in income than your care is costing you, you income-wise for long-term care purposes would qualify for Medicaid, income-wise. That has nothing to do with the assets, though. Some people may never qualify for Medicaid income-wise if they're making enough in income, which is a great place to be, of course, because care costs in our area can be quite expensive, and they are across the country as well, but they're not necessarily cheaper around us. When we're talking about care costs, what we're generally looking at is, if you're talking about at-home care, that can be the cheapest, but it can also be the most expensive. So that would be, on average, you see about $32 an hour for that cost of care. If you do the math on that, that could very quickly become the most expensive care. You can actually exceed the cost of a skilled nursing facility if that's the level of care somebody would need, just because, you're charging hourly, not by the day, like a lot of facilities do. Assisted living is sort of generally the primary starting point for most people. And that has a pretty big range in cost. And that really depends on what type of care that person's going to need. So I've seen for assisted living facilities as low as $4,000, $4,500 a month on the lower end. That generally means that person doesn't need a whole lot of extra assistance. Maybe they don't have memory care concerns just yet, like no Alzheimer's or dementia care needed. But it can easily get up to $7,000, $8,500 a month if somebody needs long-term care around Alzheimer's or dementia. So there's a really big range there in how much that can cost somebody. Skilled nursing, what most people would think of as a nursing home, is usually the most expensive. And that's where we'd be looking at right now, anywhere from usually $10,000 to $11,000 a month on the higher end. So it can be very expensive. And the concern that most people have around this is, well, I don't have the income necessary to cover that in retirement, at the time I would actually need this. Or even if, it's not necessarily just they don't have the income for it, but the rate at which they're burning through their assets is so extreme because of that disparity between their income and that cost of care that they may not be able to cover it for very long. So when we're talking about, well, how do we pay for care first and foremost? Private paying, if somebody's able to, is of course the first option there. And when I talk about private paying, I mean paying out of pocket or using insurance to cover it. So another option would be long-term care insurance, which is different than like long-term disability. Long-term care insurance is a type of insurance that somebody would specifically have to cover at-home care, assisted living level care, memory care, skilled nursing care. So it's policy specifically for that. Ideally, this is something somebody would look into at the latest, they're maybe early to mid 60s, because it can get really expensive if you wait too long. It's not going to be the right option for everybody, but first, look into it, get that answer for yourself. Don't necessarily rely on, articles online or what your neighbor is telling you it costs them, because it's going to be different for everybody, right? It's based off of you or you and your spouse. And Long-term care insurance, most of the time will cover, a certain daily amount at most, a certain max total payout, maybe a max time frame that it'll pay out. Older policies paid out forever, indefinitely. And if you have one of those, don't you dare get rid of it if you can afford your premiums, because you will never find one like that again. But it's good to be able to privately pay for 2 to 3 years if you're able to. And the reason for that is a lot of facilities are requiring 2 to 3 years of private payment before somebody would get on Medicaid, if they want to stay there. So if I were trying to go into care like that, and that's the care I needed, a lot of facilities would tell me, show us you can privately pay, 1, 2, or 3 years, depending on the facility, before you would be able to access Medicaid, because otherwise we're not going to let you stay here, or we're just not going to accept you as a resident. So you want to be able to cover 1, 2, or 3 years of care, depending again on the facility, so that you have afforded yourself the option of where you go. The more you're able to privately pay, as with really anything, the more you're able to pay out of pocket, the more options that you have in relation to your care. So where long-term care insurance can be really helpful is a way to pay for that care for a couple of years, where if you didn't have the assets to do it otherwise, or you're trying to protect one spouse or the other more from, that first spouse going into care, dipping into retirement savings, or just like any insurance, you want that extra coverage, so that you know that you have some ability to privately pay no matter what. It can be a really good tool. But once somebody is on private payment, maybe their long-term care insurance has run out, or they never had long-term care insurance. If they're paying out of pocket, they're still not going to necessarily qualify for Medicaid right away, even if their income is lower than their cost of care, because they being Medicaid are then going to look at what types of assets and how much in assets does this person have, or do they have as a married couple, and they're only going to let them keep so much. So in order to qualify for Medicaid as a single person, and I'll start there because it's the most straightforward. As a single person, if I were going into care, asset-wise, all I could have in order to qualify for Medicaid is I could keep my home, but they wouldn't force me to sell it right away. But eventually, a Medicaid lien could eat up the equity that I have in my home. So although it may not need to be sold right away, I could eventually have to lose the value of that home to the cost of care. And this is actually an important point to make too, in a common misconception. When people talk about losing the home to the nursing home, it's not the nursing home saying, sign the deed over to us. It's just that they have care costs that they have to have paid on behalf of the person in care. And if that person goes on Medicaid, Medicaid can eventually take the value of the home. So it's actually Medicaid estate recovery taking the value of the home, not necessarily the nursing home. Now, if you sell your home and then spend it on your care, yeah, that's a little different, but it's not the nursing home saying, sign it over or else. It's just pay our care costs. That's what it is. So it is a common misconception. On top of the home, with that lien on it, a single person can keep one vehicle of any value. So that's one, not multiple vehicles, and they really don't care what value is on it. I suppose it would start to get a little ridiculous if you had that Ferrari or Lamborghini that you were suddenly buying right before you went into care, right? And by the way, that is not my legal advice to do that. That would not be very smart, but they really don't care what the value of that vehicle is. Now, you do have to be careful about what you're qualifying as a vehicle. There have been people in the past who have tried to claim certain boats as vehicles that did not work because it was, not their primary mode of transportation, so to speak. The whole point of this exception is so that they can, the patient can have transportation to and from doctor's appointments if need be, help them get around a little more easily. You, as a single person, may also have not more than $1,500, so $1,500 dollars in face value for life insurance. If you have more than that, any of the cash value of that life insurance gets counted as what they would say is an available asset, meaning it gets counted towards your total you're allowed to keep. So the face value doesn't count towards that total, but the cash value can if you have more than $1,500 in face value, which most people with life insurance would be over that. Now that is not term insurance, because term insurance does not have a cash value. So if you could have $1 million in term insurance, and that's not an asset for Medicaid. You can also prepay your burial expenses up to about $15,000, and there's no hard line number on that, but that's just where it's gotten tested. Is it's been up to about $15,000 that they haven't questioned it. But it is an allowed expense. So you can prepay your burial expenses. It does have to be irrevocably assigned for that purpose. So if you pay for a policy about, for your burial, what can sometimes referred to as a funeral trust, a burial trust, or funeral insurance, it has to be irrevocably assigned for that purpose. You can't just pull the money back. Otherwise, it's still counted towards the total that you get to keep. And you can do that for yourself, spouse, children. You can do it for direct family members. You still want to be cautious about overdoing it, because that's not necessarily benefiting you either, just to spend through all that money. So prepare your burial expense, so that can be an exempt asset if it's not something you can take back. And then outside of those things, everything is countable as an asset. So the value of the home, right? The value of additional real estate, bank accounts, IRAs, any cash value of life insurance that's over that face value amount that I mentioned total. That all gets added up, and then you can only keep $2,000 at most as a single person. And that number is not ever really been adjusted upwards for inflation. It does not adjust every year for inflation. So it's been $2,000 for a long time. So in order to qualify asset-wise for Medicaid, a single person has to spend below $2,000 outside of the exempt assets that I mentioned earlier. Now, in terms of income, what somebody who's single and is on Medicaid in a facility, all they get to keep of their income every month is $45. The rest of their income must go towards their cost of care to help supplement what Medicaid is paying. It's what they call their cost share for living in the facility. So $45 a month has also not been adjusted for inflation anytime recently, and is obviously not something that goes very far anymore. It hasn't gone far for quite a long time. That's just barely covering minimal expenses, but it's what they call the personal needs allowance of the individual. So an individual obviously can't keep a whole lot and be on receiving Medicaid assistance in a facility. Now that all changes when somebody is married. And it depends on if maybe only one spouse is in care or if both spouses are in care. But in general, if only one spouse is in care, the community spouse, which is the spouse living at home, so not the one in care or in need of care, they can keep the home with no lien being placed on it. Now there is an equity cap on it. It has to be, $750,000 or less. So if you have a, $3 million home, you're probably not, it's going to be over that equity cap. But a home for that primary spouse or the community spouse, without any lien being placed on it, they don't have to count it or have any state recovery against it. That's just off the table for that community spouse. Any qualified retirement accounts, so IRAs, 401ks, 403bs, Roth or traditional, doesn't matter, as long as it's in the name of the spouse who does not need care. So the community spouse, their IRAs are protected. Their retirement accounts are protected from the other spouse's care. Now, that is not the case for the spouse who's in care. Their IRAs are still countable assets. So the spouse at home may keep some of their IRA potentially, but it is counted towards the total that they'd have to spend down for their care. So this can be both really good or really bad for protection purposes, depending on which spouse needs care first and what the breakdown is between those spouses. So it's really hard to rely on that as a way to protect assets because, you just don't know when you're contributing to these accounts, what spouse is going to need care first, right? So that is protected. The same things in relation to the life insurance I mentioned, the prepaid burial expenses, the one vehicle between both spouses, those are all off the table as well for that community spouse. But then what they're going to look at next is anything else that I didn't mention. Again, bank accounts, whether joint or separate, traditional investment accounts where they're not qualified retirement accounts, the cash value of life insurance over that $1,500 for both spouses, Additional real estate, whatever it is, they pool the value of that up and say, you still only get to keep so much of it. And how they figure out how much that community spouse gets to keep of the available assets is they will divide it in half, and it has to fall no less than $50,000. So $50,000 is the floor that spouse at home gets to keep of the available assets. So again, that's not including their IRAs, their 401ks, the primary residence, and the other exempt assets. So that's in addition to those things. But the most of that half that they get to keep right now is about $148,000. That upper range does go up every year with cost of living, inflation. So that is going to change next year. It won't be the same. It was, in the 130s when I first started practice. So it's gone up since then. But that $50,000 again does not get adjusted upward. It's always $50,000 as the floor. If your half of your available assets falls somewhere between those two numbers, you keep exactly what the half is. So the floor is 50. You can't keep more than 148 though, roughly. But if you fall between those two, you keep whatever the half is. So potentially a married couple where they are total in assets below $50,000, if one spouse went into care, they'd probably be Medicaid eligible right away. But if somebody's built up their retirement savings quite a bit and one spouse is going into care, but they don't have enough to privately pay forever, sort of the people in between those two, that's still a lot that they might have to spend through in order to get that one spouse qualified for care. Now, in terms of income, the spouse at home can keep all of the income coming in their name. So they could be in theory making $20,000 a month, which would be great, but they could keep that amount and not have to spend it on their spouse's care. However, if they themselves are below about $3,000 a month in income, they can shift some of that spouse who's in care, they can shift some of their income over to the community spouse and get them at most up to that point. So some spouses, if together they're below that amount in income, they might get to keep all of the income between the two of them. It just depends. And again, this can be a pretty big change in quality of life, though, if the spouse who has the higher amount of income goes into care first. So in my example, where somebody, let's say, is getting 10 grand a month in income, but their cost of care is 11, well, the spouse at home can still only keep 3 grand at most of that income in total with their own income coming in. So if that spouse at home was bringing in $0 in income, they'd keep 3 of that other spouse's income. If they were only getting $1,000 in income and Social Security themselves, they'd only keep 2 grand. So it's 3 grand total is what they can get up to. So that could still be a pretty big quality of life change for that person. Obviously, in order to get qualified for Medicaid, a lot of people don't want to spend all the way down to that, or they don't want to wait to that point because then they have nothing left, right? So they try to find ways to protect assets. And this is where things can be very dangerous to engage in some of these planning mechanisms if you don't have good advice. A lot of people ask questions about gifting. Should we gift to the kids, or is there a certain amount we can gift to the kids and have it be okay for Medicaid? And so what most people are thinking of when they're talking about that amount that could be okay is they're thinking about the gift tax exclusion for tax purposes, estate tax purposes. That number is $17,000 per person per year, but for Medicaid, that number is actually $0 per year. They don't want you to be able to gift money of any amount to the kids. So don't gift $17,000 to each of your kids every year thinking you're somehow getting around that 5-year look back for Medicaid, because that is still a divestment for Medicaid. And if you needed care and needed Medicaid assistance within 5 years of any of those gifts, you would have to report them to Medicaid. And no, you can't just not tell Medicaid about it. That's actually a fraud. So you do have to tell Medicaid about those gifts. It's an affirmative duty that you have when you fill out an application. So you'll also hear questions about, should I put the home in the kid's name? If I'm getting ahead of the 5 years, is that something I should do? Put the home directly into the name of the kids? And generally speaking, it's not the best idea to put the home in the kid's name. It's usually a pretty bad idea to put the home directly in the name of the kids. And the concern we have with that, and that's part of what this home chart is that we're sending out to you all, is there's really, I guess, three big concerns that I would have. First and foremost is it's a huge loss of control. When you just put something in somebody else's name, you don't own it anymore, right? You have no direct say over it anymore without some other sort of agreement being in place. Number two, it's just really bad tax planning. So when you gift an asset like the home or stocks over to the kids, whatever your cost basis was in that property gets transferred over to them. So they don't get that cost basis at fair market value. And that's how you determine when you sell that property, what sort of capital gains tax might have to be paid. Now, most of us don't have to pay capital gains tax on the sale of our home because we have what's called a 121 exclusion, which is an exclusion from capital gains of the sale of our primary residence up to about $250,000 per person. So, most people don't have more than a $250,000 or $500,000 if they're married gain on their home when they sell it. However, the kids, if that's not their primary residence, are not going to have that same exclusion. So if you transfer whatever you paid for the home over to them and then they sell it way down the road, they're going to have to pay 15 to 20% in capital gains tax, depending on where their income brackets fall. So it's probably not the plan to say, hey, let's give 20% of our value of our home over to the IRS. Most people I talk to don't really want to pay taxes more than they have to. So, tax-wise, it's just not good planning. If the kids had inherited that property, then they could have received that property for tax purposes at fair market value. Then if they turn around and sell it right away, there's little to no gain that they have to pay any tax on. So tax-wise, you'd much rather inherit property like a home or stocks, anything with a cost basis associated with it. But really the biggest concern I have when people put the home directly in the kid's name is that it is not safe because whatever happens to the owner of a property happens to that property. So you could have kids that you put, the home directly in their name, but what happens if one of them gets sued or they file for bankruptcy or they get divorced or they pass away? Any of those things that happens to them after you've put the home in their name potentially happens to your home. So you might get around the 5-year look back for Medicaid and have it off the table for your care, but then you might have some other sort of issue come up with any one of the kids that is, there's nothing you can do about it, right? You don't control that home anymore. It's not yours. You don't have protections from other people's liabilities. It's not their primary residence anymore. And even those primary residence protections from those things aren't really all that great. So just, you open your own property up to the liabilities of those children. And even the most responsible kids in the world, things can go wrong. I mean, bankruptcy can happen to very responsible people if there's medical debt. Divorces happen, quite frequently, right? That's where you hear about that, 50% rate, which I think is a little less now, but still pretty common. And if they're in high liability careers, attorneys, doctors, lawsuits happen, business owners, small business owners. You just have to be very careful about opening up your property to the liability of others. Now, I'm running a little short on time, so I'll try to summarize this quickly for you. But if you're trying to protect the value of your home from spend down, or the value of any asset in reality, from having to be spent down to those amounts I talked about, it's generally safer to use what's called an irrevocable trust to do so. How that functions is you still give up the property over to that trust. You shouldn't be your own trustee under most circumstances. So you usually are appointing one or more of the kids as that trustee. However, when you transfer that property over, we always have our clients sign what's called an occupancy agreement, which says, hey, as long as they continue to pay the property taxes, the original owners, that is, they can't be evicted, they can't be charged rent, the kid can't kick them out or sell the property without their permission. It's still a part of their estate when they pass away, so it still gets that step up in cost basis. And most importantly, the trustees of that trust do not own the trust, they manage it. So if they have a liability that comes up during lifetime, it's not then going to happen to the trust itself. If somebody has a trustee that passes away, they may need to appoint a new one or have somebody appoint a new one, but that doesn't mean that their home is suddenly going to be subject to the risks or liabilities of that individual or the estate plan of that individual. So with irrevocable trusts, you can protect still, it still counts against the 5 years. So you still want to try to do this prospectively if you can, but it's much safer from those concerns I mentioned earlier than it would be to just put the home directly in the kid's name. And now I am out of time here, but there is one more important thing I do want to mention before I go. If anybody tries to talk to you currently about doing what's called a life estate deed, just know that that hasn't really been valid planning for close to 10 years at this point. So what a life estate deed is, prior to August of 2014, you could grant a life estate interest to yourself and then give that remainderment interest over to your kids. And how that worked is, as you got older, you owned less and less of your home and the kids owned more and more of it percentage wise. And if it was done prior to August 1st of 2014, and if you have one of these and it was done prior to that point, then as long as it's been done 5 years before you need Medicaid, it's both off the table for Medicaid and it's unavailable for the estate recovery component where Medicaid can come in as a creditor of your estate. However, if anybody has a life estate deed that was done after that date, after August 1st of 2014, just know that that is not protected from the estate recovery side of things. So Medicaid can come in as a creditor of that remaining interest that that person had and recover against it. I have fixed a lot of these that people have done. I've seen some done in 2016 or 2017. So just don't go into a life estate deed right now thinking that if you don't already have one that was done prior to August 1st of 2014, that there is not that protection from estate recovery, Medicaid coming in as a creditor. You would still be much better off using an irrevocable trust. And quite frankly, we favored irrevocable trusts over those even when they still worked for that purpose, because there were some other drawbacks to them as well. So I'm a little over time and I don't want to keep you guys too long. And there's a lot of, about this topic. So I'm sure we'll have more follow-ups to this, down the road. And if you're really interested in hearing a whole lot about it, you can come to our Wills versus Trust Public Seminar on May 10th. We talk a lot about this. We have a lot more time to talk about it too. But again, keep an eye out for those handouts from us, that graph of the home or chart of the home, the feedback form where you can let us know if you'd like to reach out to us, or have us reach out to you to set aside time for an initial consultation. Again, those are complimentary, so you're not paying us anything coming to talk to us initially. We can give you a good idea of cost by the end of that meeting, generally speaking. So with that, thank you all for listening to me talk about Medicaid for 30 minutes or so. I hope to see you guys all at the in-person public seminar in a couple weeks here, and hopefully for our following week webinar as well, our evening webinar. Thank you, and I hope you have a good day.